Unit 5, Transfer of Title to Real Property. Learning Objectives. When you have completed this unit, you will be able to accomplish the following. Identify and describe the methods of transferring title, the essential and non-essential elements of a deed, and the three major types of deeds used in North Carolina, and the reason why special-purpose deeds would be used. Explain the processes of title examination and recordation. Describe different methods of title assurance, including title search, title insurance, and title recordation. Calculate excise tax due when property is transferred. Key terms: abstract of title, action to quiet title, adverse possession, alienation, American Land Title Association, bargain and sale deed, chain of title, cloud on the title, condemnation, counteract, constructive notice, covenant, deed, delivery and acceptance, eminent domain, escheat, excise tax, general warranty deed, grantee, granting clause, grantor, intestate, marketable title act, North Carolina Intestate Succession Act, quitclaim deed, recording, special warranty deed, title insurance, title search, will. Learning objective. Identify and describe the methods of transferring title, the essential and non-essential elements of a deed, and the three major types of deeds used in North Carolina, and the reason why special-purpose deeds would be used. Methods of transferring title. Title to real estate means the right to or ownership of the land. The word title also is used to refer to the documentary evidence of the right of ownership, such as a deed. The word title refers to a summation of all the things property owners possess to prove and protect their ownership interest in property. The term title has two functions. It represents the bundle of legal rights the owner possesses in the real estate, and it denotes the facts that, if proven, enable a person to recover or retain ownership or possession of a parcel of real estate. A parcel of real estate may be transferred voluntarily by sale or gift, or it may be taken involuntarily by operation of law. In addition, it may be transferred by will or descent after a person has died. Transfer of title is referred to as alienation, which means the act of transferring property to another. Voluntary alienation. Most transactions utilizing real estate brokers involve voluntary alienation. Voluntary alienation of title may be made by either gift or sale with the wishes and consent of the property owner. To transfer title by voluntary alienation during an owner's lifetime, that owner must use some form of deed. A deed is a written instrument by which an owner of real estate intentionally conveys right, title, or interest in the parcel of real estate to another. A deed is evidence of title. The owner is referred to as the grantor, and the person who receives title is called the grantee. A deed is executed only by the grantor. The grantee does not sign the deed. Legal terms for parties in real estate transactions. In reference to parties to a real estate instrument, such as a deed, the parties are referred to in legal terms such as grantor and grantee. The or is the giver of the paper, and the e is the receiver of the paper. Type of document: giver, receiver, deed, grantor, grantee, offer, offerer, offeree, counteroffer, offerer, offeree, lease, lessor, lessee, mortgage, mortgager, mortgagee, option, optioner, optionee, installment contract, vendor, vendee, will, divisor, divisee, contract, vendor, vendee. Requirements for a valid conveyance. A valid deed must contain certain essential elements, including the following. The deed must be in writing. The grantor must have the legal capacity to execute a deed. Grantee named with reasonable certainty must be identified. There must be adequate words of conveyance. There must be an accurate legal description of the property conveyed. The deed must be signed by the grantors. The deed must be delivered to and voluntarily accepted by the grantee. Grantor. A grantor must have a legal existence, be of lawful age, and be legally competent in order to convey title to real estate. A grantor generally is held to have sufficient mental capacity to execute a deed if that grantor is capable of understanding the action. A deed executed by a person while mentally impaired is only voidable. It is not void. A deed executed by a person who has been judged legally incompetent is considered to be void. Identification of grantor and grantee. To be valid, a deed must name both the grantor and the grantee in such a way that they are readily identifiable. Furthermore, the grantee must be a real person, either a natural person or an artificial person, such as a corporation. A deed naming the grantee as a fictitious person, a company that does not exist, or a society or club that is not properly incorporated is considered void. The grantee cannot be a dead person but may be a minor. A minor may receive real property via deed but may not legally convey the property until after turning 18. Consideration. Consideration of some form must be stated. To be legally binding, the deed must express adequate consideration. Consideration is the price paid for the promises stated in the deed. While economic value is the most common form of consideration, consideration does not have to involve money. Deeds can state that the property is being exchanged for love and affection. Deeds in many, if not most, cases do not recite the actual sales price. Instead, they simply recite for $10 paid in good and valuable consideration, the receipt and sufficiency of which are hereby acknowledged. Words of conveyance. A deed of conveyance transfers a present interest in real estate, and it must contain words that state the grantor's intention to convey the property at this time. An expression of intent to convey at some future time is inadequate. Such words of conveyance are often called the granting clause. Depending on the type of deed and the obligations agreed to by the grantor, the wording is generally convey and warrant, grant, bargain, and sell or remise, release, and quitclaim. Legal description. To be valid, a deed must contain an acceptable, accurate, legal description of the real estate conveyed. Land has been described adequately if a competent surveyor could locate the property from the description used. The rules relative to describing real estate are discussed in a different section of this course. Signature of grantor. To be valid, a deed must be signed by all the grantors named in the deed. In North Carolina, if the grantor is married, both the grantor and the grantor's spouse must sign the deed even if only one spouse is named in the deed. Delivery. Before a transfer of title by conveyance can take effect, there must be delivery and acceptance, that is, actual delivery of the deed by the grantor and either actual or implied acceptance by the grantee. Delivery may be made by the grantor to the grantee personally, or to a third party who is authorized by the grantee to accept the deed. Title is said to pass when a deed is delivered and voluntarily accepted. In North Carolina, recordation of the deed by the buyers or their agent is recognized as acceptance. The effective date of the transfer of title from the grantor to the grantee is the date of delivery of the deed itself. Elements that are not required. Non-essential elements often appear in deeds but are not required for validity. Non-essential elements include the following. Deeds do not have to be witnessed. Deeds do not have to be dated, although, for practical matters, it may be wise to do so. Deeds do not have to include a statement as to the exact amount of consideration. Deeds do not have to be acknowledged. Deeds do not have to be recorded to be valid, but under the Connor Act, the grantees must record the valid deed to protect their interest as to third parties under the law. Effective in 1999, deeds do not have to be sealed in North Carolina to be valid. Standard deed forms may continue to have the word seal after the signature. However, it is no longer required to create a valid deed. Signing under seal does have certain legal advantages, such as extending the statute of limitations, protecting the parties' rights from 3 years to 10 years. Note that acknowledgement is necessary before a deed can be recorded, and recording a deed is necessary to protect the grantee's interests in the property. Types of deeds. There are 3 common forms of deeds: the general warranty deed, the special warranty deed, and the quitclaim deed, and in North Carolina, several types of special purpose deeds are used. General warranty deed. For a purchaser of real estate, a general warranty deed provides greater protection than any other deed. It is the best deed for the grantee, but it gives the grantor the greatest degree of liability. It is referred to as a general warranty deed, a full covenant and warranty deed, or simply a warranty deed because the grantor is legally bound by certain basic covenants or warranties. Covenant of cession and the right to convey. The grantor warrants that he or she is the legal owner of the property and has the right to convey title to it. Delivery of cession is the actual transfer of title. Covenant against encumbrances. The grantor warrants that the property is free from any liens or encumbrances except those of record. Encumbrances would generally include such items as mortgages, mechanics liens, real estate tax liens, protective covenants, and easements. Covenant of quiet enjoyment. The grantor guarantees that the grantee's title will be good against third parties who might bring court actions to establish superior title to the property. If the grantee's title is found to be inferior, the grantor is liable for damages. Covenant of further assurance. The grantor promises to obtain and deliver any instrument needed to make the title good. For example, if an error in the deed is found, the grantor agrees to resign a new deed to correct the mistake. Covenant of warranty forever. The grantor guarantees that if at any time in the future the title fails, he or she will compensate the grantee for the loss sustained. However, it is in the best interest of the grantee to obtain title insurance because at the time of a later claim, the grantor may be dead or financially insolvent. These covenants in a general warranty deed are not limited to matters that occurred during the time the grantor owned the property. They extend back to its origin. Note that the first 3 covenants are most important. Special warranty deed. A conveyance that carries only 2 covenants is called a special warranty deed. The grantor warrants that he or she received title to the land and that the property was not encumbered during the time he or she held title except as noted in the deed. Special warranty deeds generally contain the words remise, release, alienate, and convey in the granting clause. Any additional warranties to be included must be specifically stated in the deed. Bargain and sale deed. A bargain and sale deed contains no express warranties against encumbrances. However, it does imply that the grantor holds title and possession of the property. The granting clause usually states a person's name or name of an entity, and the words grants and releases or grants, bargains, and sells. Because the warranty is not specifically stated, the grantee has little legal recourse if title defects appear later. In some areas, this deed is used in foreclosures and tax sales. A buyer should purchase, or the seller provide, title insurance for protection. A covenant against encumbrances initiated by the grantor may be added to a standard bargain and sale deed to create a bargain and sale deed with covenant against the grantor's acts. This deed is closely equivalent to a quitclaim deed. Warranties used in general warranty deeds may be inserted in a bargain and sale deed to give the grantee similar protection. Quitclaim deed. A quitclaim deed provides the grantee with the least protection of any deed. It carries no covenant or warranties and conveys only such interest, if any, that the grantor may have when the deed is delivered. By a quitclaim deed, the grantor only remises, releases, and quitclaims an interest in the property to the grantee. The deed might convey an easement, it might reconvey equitable title back to a seller, it might convey nothing at all. If the grantor under a quitclaim deed has no interest in the property described, the grantee acquires nothing by virtue of the quitclaim deed and does not acquire any right of warranty against the grantor. A quitclaim deed can convey title as effectively as a warranty deed if the grantor has good title when the deed is delivered, but it provides none of the guarantees of a warranty deed. A quitclaim deed is frequently used to cure a defect, called a cloud on the title, in the recorded history of a real estate title. For example, if the name of the grantee is misspelled on a warranty deed placed in the public record, a quitclaim deed with the correct spelling may be executed to the grantee to perfect the title. A quitclaim deed is sometimes used to convey ownership rights from one spouse to the other in a divorce agreement. A quitclaim deed also is used when a grantor allegedly has inherited property, but is not certain of the validity of the title of the decedent from whom the property was inherited. The use of a warranty deed in such an instance could carry obligations of warranty, while a quitclaim deed would convey only the grantor's interest. In practice, a licensed real estate broker in North Carolina is prohibited from drafting a deed for others, and is also prohibited from filling in the blanks of a deed form for others. While a licensed real estate broker may prepare a deed to convey the broker's own property, an attorney should be consulted for all deed preparations. North Carolina Special Purpose Deeds. There are many specialized forms of deeds used in North Carolina for various specific purposes. A few significant examples of these are discussed in the following paragraphs. Correction deed. A correction deed is used when there has been an error in a previous deed. For example, if the description of the property in the original deed was incorrect, a correction deed will be used to make the correction. Errors in names or dates would also be corrected by this deed. Deed of gift. When a grantor conveys property as a gift, a deed of gift is used. A deed of gift must be recorded within 2 years or it becomes void. Because no consideration is exchanged, there is no need to pay excise tax. Deed of release. A deed of release is used to release a parcel of property from a mortgage or deed of trust lien when the real estate loan has been paid in full. Trustee's deed. A deed of conveyance executed by a trustee is a trustee's deed and is used when a trustee named in a will, trust agreement, or trust deed conveys the real estate to anyone other than the truster. The trustee's deed sets forth the fact that the trustee executes the instrument in accordance with the powers and authority granted to him or her by the trust instrument. A trustee's deed is generally used to transfer title after a foreclosure auction. Timber or mineral deed. Some ownership rights can be severed from the land and transferred by deed, such as the harvesting of timber or minerals located on the property. Deeds executed pursuant to court order. This classification covers deeds such as a sheriff's deed, a tax deed, a guardian's deed, and an executor's deed. These deeds are used to convey title to property that is transferred by court order or by will. One characteristic of these special purpose deeds is that the full consideration is usually stated in the deed. This is done because the deed is executed pursuant to a court order, because the court has authorized the sale of the property for a given amount of consideration. This amount should be exactly stated in the document. Involuntary alienation. Title to property also can be transferred by involuntary alienation, that is, without the owner's wishes or consent. Such transfers are usually carried out by operation of law and range from government condemnation of land for public use to the sale of property to satisfy delinquent tax or mortgage liens. Involuntary alienation. Escheat. When a person dies intestate and leaves no heirs, the title to that person's real estate passes to the state by the state's power of escheat. Eminent domain. Federal, state, and local governments, school boards, some government agencies, and certain public and quasi-public corporations and utilities have the power of eminent domain. Eminent domain is the right of the government to acquire privately owned real estate for public use. Condemnation is the process by which the government exercises this right, by either judicial or administrative proceedings. In the taking of property, just compensation is to be paid to the owner, and the rights of the property owner are to be protected by due process of law. Ideally, the public agency and the owner of the property in question agree on compensation through direct negotiation, and the government purchases the property for a price considered fair by the owner. In some cases, the owner may simply dedicate the property to the government as a site for a school, park, or another beneficial use. Sometimes, however, in cases where the owner's consent cannot be obtained, the government agency can initiate condemnation proceedings to acquire the property. Even in the taking of the property through condemnation, the property owner must be paid just compensation. If the taken property was leased, the tenant will be entitled to compensation for damages caused by the termination of the tenancy. Generally, states delegate their power of eminent domain to cities and counties or public entities for public services. For instance, a public housing authority might take privately owned land to build low-income housing, or the state's Land Clearance Commission or Redevelopment Authority could use the power of eminent domain to make way for urban renewal. If there was no other feasible way to do so, a railway, utility company, or state highway department might acquire farmland to extend railroad tracks, bring electricity to a remote new development, or build a highway. In the past, the proposed use for taking property was to be for the public good. However, in June 2005, the U.S. Supreme Court in Kelo v. City of New London significantly changed the definition of public use. The court held that local governments can condemn homes and businesses for private or economic development purposes. In Kelo v. City of New London, a development agent, on behalf of the city, initiated condemnation proceedings on land owned by 9 property owners who refused to have their property taken. The development plan involved land for commercial, residential, and recreational purposes. The court noted that the development plan was not going to benefit a particular class of identifiable individuals. Further, although the owners' properties were not blighted, the city determined that a program of economic rejuvenation was justified and entitled to deference. Economic development fit within the broad definition of the term public purpose. The court found that the city's proposed disposition of petitioners' properties qualified as a public use within the meaning of the Takings Clause of the Fifth Amendment of the U.S. Constitution. In this case, the city had invoked a state statute that authorized the use of eminent domain to promote economic development. The court decision leaves it to the states to establish rules that cities must follow when exercising eminent domain powers. In response to this court decision, many state legislators have enacted legislation to impose a narrower definition of the term public use in eminent domain proceedings to stop condemnations justified on purely economic grounds. Like many state legislatures, North Carolina's General Assembly reacted to the Kelo decision by clarifying state laws governing the power of eminent domain. In 2006, North Carolina clarified that eminent domain may only be used to take a blighted parcel. Consequently, the Kelo decision is not currently applicable in North Carolina. North Carolina also recognizes a quick-take method of condemnation. When authorized by law, title and possession of private property can immediately be transferred to the public authority. Furthermore, a taking of a leased property terminates any existing lease on that property. Lien foreclosure. Land also may be transferred without an owner's consent to satisfy debts contracted by the owner that have become liens against the real property. In such cases, the liens are foreclosed, the property is sold, and the proceeds of the sale are applied to pay off the debts. Debts that could be foreclosed include mortgage loans, real estate taxes, mechanics liens, and general judgments against the property owner. Adverse possession. Adverse possession is another means of involuntary transfer. For persons to make a claim of ownership under adverse possession, they must have some reason to believe the land is theirs. Owners who do not use or inspect their land for a number of years may lose title to another person who makes a claim to the land, takes possession, and, most importantly, uses the land. The mnemonic ocean reminds us that the possession of the claimant must be the following: open, continuous, exclusive, adverse to the true owner's possession, notorious, hostile. In North Carolina, the required period of continuous possession varies widely, depending on the circumstances. If the adverse possessor is trying to acquire privately owned property and has color of title, the period of possession is 7 years. If there is no color of title, the period of possession is 20 years. Property owned by the government is not subject to acquisition by adverse possession. Even if the adverse possessor fulfills all the legal requirements for adverse possession, he or she must go to court to get clear title to the property. This is done with a lawsuit called an action to quiet title. It is difficult to prove title by adverse possession, and until a court decides that title has been acquired, the claimant's title is considered to be unmarketable. Transfer of a deceased person's property. By descent. Every state, including North Carolina, has a law known as a statute of descent and distribution. When a person dies intestate, the decedent's real estate and personal property pass to the decedent's heirs according to this statute. In effect, the state makes a will for anyone who did not do so. A court appoints a person to distribute the deceased's property according to the provisions of the North Carolina Intestate Succession Act. This person is called an administrator if a man or an administratrix if a woman. As noted previously, if the property owner dies intestate and leaves no heirs, the property will escheat to the state of North Carolina. North Carolina's provisions for intestate succession are quite complicated, and a lawyer should be consulted when intestate succession questions arise. Transfer of title by will. A will is an instrument made by a mentally competent owner to convey title to real and personal property on the owner's death. A will takes effect only after death. Until that time, any property covered by the will can be conveyed by the owner and thus removed from the owner's estate. An ownership interest, such as joint tenancy or tenancy by entirety, that contains survivorship rights cannot be affected by a will. In North Carolina, if spouses own property is tenants by the entirety, that property cannot pass by will. Neither spouse can disinherit the other spouse by will. The gift of real property by will is known as a devise, and a person who receives real property by will is known as a divisi. Technically, an heir is one who takes property by the law of descent, but the term is commonly used to include divisees as well. A legacy or bequest is a gift of personal property. The person receiving personal property is known as a beneficiary. In North Carolina, the term devise can be broadly used to refer to both real and personal property. The North Carolina Intestate Succession Act provides for the distribution of the property of an intestate person. This statute allows for the equal division of property among eligible heirs, or, in the event of no heirs, having the property escheated to the North Carolina State Educational Assistance Authority. This statute does not override an active survivorship clause in a deed. Learning objective. Explain the processes of title examination and recordation. Title in public records. Title records. Public records are just that, records that are open to the public, which means that anyone interested in a particular property can review the records to learn about the documents, claims, and other details that affect its ownership. A prospective buyer, for example, needs to be sure that the seller can convey clear title to the property. If the property is subject to any liens or other encumbrances, a prospective buyer or lender needs to know. An attorney or title company typically performs a search of the public records to ensure that good title is being conveyed. Nonetheless, it is important for a real estate licensee to understand what is in the public record and what the searchers are likely to find. Public records. Public records contain detailed information about each parcel of real estate in a city or a county. These records are crucial in establishing ownership, giving notice of encumbrances, and establishing priority of liens. They protect the interests of real estate owners, taxing bodies, creditors, and the general public. A real estate recording system includes written documents that affect title, such as deeds and mortgages. Public records regarding taxes, judgments, probate, and marriage also may offer important information about the title to a particular property. Public records are maintained by recorders of deeds, county clerks, county treasurers, city clerks, collectors, and clerks of court. For example, prospective buyers rarely search public records for evidence of title or encumbrances themselves. Instead, title companies, attorneys, and lenders conduct the searches. Recording. Recording is the act of placing documents in the public record. The specific rules for recording documents are a matter of state law. Although the details may vary, all recording acts essentially provide that any written document that affects any estate, right, title, or interest in land must be recorded in the county where the land is located to serve as public notice. This way, anyone interested in the title to a parcel of property will know where to look to discover the various interests of all other parties. Recording acts also generally give legal priority to those interests. Recorded first, the first in time, first in right, or first come, first served principle. To be eligible for recording, a document must be drawn and executed according to the recording acts of the state in which the real estate is located. For instance, a state may require that the parties' names be typed below their signatures, or that the document be acknowledged before a notary public. In some states, the document must be witnessed. Others require that the name of the person who prepared the document appear on it. States may have specific rules about the size of documents and the color and quality of paper they are printed on. Electronic recording, using computers or fax machines, for instance, is permitted in a growing number of localities. Some states require a certificate of real estate value and the payment of current property taxes due for recording. Notice. Anyone with an interest in a parcel of real estate can take certain steps, called giving notice, to ensure that the interest is available to the public. The two basic types of notice are constructive notice and actual notice. Constructive notice is the legal presumption that information may be obtained by an individual through due diligence. Properly recording documents in the public record serves as constructive notice to the world of an individual's rights or interest, as does the physical possession of a property. Because the information or evidence is readily available to the world, a prospective purchaser or lender is responsible for discovering the interest. Actual notice means not only that the information is available, but also that someone has been given the information and actually knows it. An individual who has searched the public records and inspected the property has actual notice, also known as direct knowledge. If it can be proved that an individual has had actual notice of information, that person cannot use a lack of constructive notice to justify a claim. Priority. Priority refers to the order of when documents or liens were recorded. Many complicated situations can affect the priority of rights in a parcel of real estate. Who recorded first, which party was in possession first, or who had actual or constructive notice. How the courts rule in any situation depends, of course, on the specific facts of the case. These are strictly legal questions that should be referred to the parties' attorneys. For example, buyer A purchased a property from seller B and received a deed. Buyer A did not record the deed but took possession of the property in June. In November, seller B sold the same property to buyer C, who received a deed, which buyer C promptly recorded. Buyer C never inspected the property to determine whether someone was in possession of it. By taking possession of the property, buyer A may have a superior claim to the property even though buyer A did not record. However, in some states, such as North Carolina, buyer C may have a superior claim since he recorded the deed. Unrecorded documents. Certain types of liens are not recorded. Real estate taxes and special assessments are liens on specific parcels of real estate, and are not usually recorded until some time after the taxes or assessments are past due. Inheritance taxes and franchise taxes are statutory liens and are placed against all real estate owned by a decedent at the time of death, or by a corporation at the time the franchise taxes became a lien. Like real estate taxes, they are not recorded. Notice of these liens must be gained from sources other than the recorder's office. Evidence of the payment of real estate taxes, special assessments, municipal utilities, and other taxes can be gathered from paid tax receipts and letters from municipalities. Creative measures are often required to get information about off-the-record liens. Chain of title. Chain of title is the record of a property's ownership. Beginning with the earliest owner, a title may pass to many individuals. Each owner is linked to the next so that a chain is formed. An unbroken chain of title can be traced through linking conveyances from the present owner back to the earliest recorded owner. Chain of title does not include liens and encumbrances or any other document not directly related to ownership. If ownership cannot be traced through an unbroken chain, a gap in or cloud on the chain of title is said to exist. In these cases, the cloud on the title makes it necessary to establish ownership by a court action called a suit to quiet title. For instance, a suit might be required when a grantor acquired title under one name and conveyed it under another name. There may be a forged deed in the chain, after which no subsequent grantee acquired legal title. Watch the video to learn more about public records. Learning objective. Describe different methods of title assurance, including title search, title insurance, and title recordation. Title assurance. Under the terms of a typical real estate sales contract, the seller is required to deliver marketable title to the buyer at the closing. To be marketable, a title must meet 5 criteria: be free from any significant liens and encumbrances, disclose no serious defects, be free of doubtful questions of law or fact to prove its validity, protect a purchaser from the hazard of litigation or any threat to quiet enjoyment of the property, and convince a reasonably well-informed and prudent person, acting on business principles and willful knowledge of the facts and their legal significance, that the property could in turn be sold or mortgaged at a fair market value. Most people spend more money on the purchase of real estate than on any other single item. Therefore, it is understandable that buyers want to be sure they get what they pay for, marketable title to the property. So while a deed might contain several warranties of title, the buyer should insist on a title search and a property survey to make sure he or she is getting marketable title. Title search. A title search is the examination of all public records that might affect a title. The title examiner tries to establish a chain of title, which shows the record of ownership of the property over a period of time, depending on the length of the title search. In the United States, chains of title in colonial states frequently date back to a grant from the King of England. In those states admitted to the Union after the formation of the United States, the deeds of conveyance in the chain of title generally stem from the patent issued by the U.S. government. A lawyer, a trained paralegal, or title company staff in some states can perform a title search or title examination, but only attorneys may give an opinion of title. Real estate brokers are prohibited from giving an opinion on the condition of a title. Through the chain of title, the ownership of the property can be traced backward from its present owner to its source. This thorough, condensed history of the title is called an abstract of title. Frequently, the title examination is conducted for a shorter period of time based on local custom or practical considerations. Most title defects are revealed in a search that traces back 30 to 60 years, especially if title insurance has been in place. Ownership is traced by means of searching the grantee and grantor indices that are kept in the Register of Deeds offices. Under this system, all documents relating to a parcel of property are indexed under the names of the grantors and the grantees, not under the property itself. If there is a period for which ownership is unaccounted, there is a gap in the chain. In such cases, it is usually necessary to establish ownership by a court action called a suit to quiet title. The court's judgment, following a proceeding in which all possible claimants are allowed to present evidence, can be filed. A suit to quiet title may be required when, for instance, a grantor has acquired title under one name and conveyed title under a different name. Title acquired by adverse possession also can be established of record by a quiet title action. When a title examination is conducted, the title examiner lists each instrument in chronological order along with information relative to taxes, judgments, special assessments, surveys, easements, and the like. The title examiner concludes with an opinion of title indicating which records were examined and when, and stating the examiner's opinion of the quality of the title. The grantor and grantee index system is used in North Carolina to examine the title. Any defect of title will appear in the Grantor Index. Marketable Title Act. North Carolina's Marketable Title Act provides that if a chain of title can be traced back for 30 years, and no other claim has been recorded during that time, the title becomes a marketable title. Any conflicting claims predating the 30-year chain of title may be extinguished. The practical effect of this act is to eliminate obsolete defects in the chain of title. Title insurance. A title insurance policy is a contract by which a title insurance company agrees, subject to the terms of its policy, to indemnify the insured against any losses sustained as a result of defects in a title that existed at the time the policy was issued, other than those exceptions listed in the policy. Title companies issue various forms of title insurance policies. The most common are the owner's title insurance policy and the lender's title insurance policy. As the names indicate, each type of policy is issued to insure specific interests. An owner's policy insures an owner's interest in property. A lender's policy insures a lender's interest in property. The owner's coverage is usually the face amount of the purchase price, and the owner is permanently protected. The lender's coverage is limited to the loan amount and is of a diminishing liability. Lender's coverage ends with the payoff of the mortgage loan. Marketable title versus insurable title. A marketable title has no defects or clouds in the chain of ownership. An insurable title may have a defect or cloud, but an insurer agrees to protect the buyer against the known defect. A standard coverage policy usually insures against defects that may be found in the public records plus many defects not found there. The extended coverage provided by an American Land Title Association policy includes all the protection of a standard policy plus additional protection to cover risks that may be discovered only through inspection of the property or revealed by examination of an accurate survey. The company does not insure against any defects in or liens against the title that are found by the title examination and listed in the standard policy. The Alta owner's title insurance policy protects the owner against title defects not found in the public records, such as falsification of the records, misrepresentation of the true owner of the land, old unsettled estates, forged deeds, releases, or wills, instruments executed under a fabricated or expired power of attorney, errors in copying and indexing, deeds delivered after the death of a grantor or grantee or without consent of the grantor, mistakes in recording legal documents, undisclosed or missing heirs, birth or adoption of children after the date of the will, deeds by persons of unsound mind, deeds by persons supposedly single but secretly married, and deeds by minors. The consideration for the policy is paid once at closing for the life of the policy. The maximum loss for which the company may be liable cannot exceed the face amount of the policy. When a title company settles a claim covered by a policy, it can then step into the shoes of the insured party and seek compensation from anyone responsible for the settled claim. With the owner's title insurance policy, if the insured owner were to lose title because of a covered claim, the title company would pay the owner the value of the property up to the face amount of the policy. The title company also assumes any costs incurred in the defense of the title. ALTA coverage is summarized in Owner's Title Insurance Policy. Owner's Title Insurance Policy. Standard coverage. Extended coverage. Not covered by either policy. Defects found in public records. Forged documents. Incompetent grantors. Incorrect marital statements. Improperly delivered deeds. Standard coverage plus defects discoverable through property inspection, including unrecorded rights of persons in possession. Examination of survey and unrecorded liens not known by policyholder. Defects in liens listed in policy. Defects known to buyer. Changes in land use brought about by zoning ordinances. Defects that would have been shown by an accurate survey if a survey was not done. North Carolina is considered an approved attorney state. That means that title searches are usually performed by an attorney rather than by a title insurance company. When the title search is completed, the attorney submits a preliminary opinion on title to the title insurance company, which, in essence, serves as an application for title insurance. Based on the preliminary opinion on title, the title insurance company issues a title commitment. The title commitment includes a description of the title insurance policy, the name of the insured party, the legal description of the real estate, the estate or interest covered, a schedule of all exceptions consisting of encumbrances and defects found in the public records, and conditions and stipulations under which the commitment is issued. The title commitment is used at closing as assurance of a clear title to the property in question. In practice, the NCBA NCOR 2T offer to purchase and contract used by realtors in North Carolina establishes the terms of sale regarding a number of title matters in the following paragraph. Seller shall execute and deliver a general warranty deed for the property in recordable form no later than settlement, which shall convey fee simple marketable and insurable title, without exception from mechanics liens and free of any other liens, encumbrances or defects, including those which would be revealed by a current and accurate survey of the property, except ad valorem taxes for the current year, utility easements and unviolated covenants, conditions or restrictions that do not materially affect the value of the property, and such other liens, encumbrances, or defects as may be assumed or specifically approved by buyer in writing. The property must have legal access to a public right-of-way. After closing, the attorney issues a final opinion on title, which includes recording information for the deed and deed of trust and so forth. The final opinion on title goes to the title insurance company, which issues the title insurance policy based on this information. Under the title insurance policy, the title insurance company promises to defend the title as insured, as well as to pay any claims against the property if the title proves to be defective. This coverage begins after closing and issuance of the policy, and covers only title defects undiscovered before closing or not exempted in the title commitment. The opinion issued by the attorney is just that, an opinion based on the search of public records. It is not a guarantee of good title. In practice, before a lender will forward money on a loan secured by real estate, it normally orders a title search at the expense of the borrower to assure itself that there are no recorded liens superior in priority to its mortgage on the property. The lender also typically requires the borrower to purchase a title insurance policy to protect the lender's interest. The owner-borrower may also purchase an owner's policy. An owner's policy is highly recommended, but the owner-borrower must request this policy since it is not automatic. Title recordation. Both title insurance and title examinations depend on the fact that all conveyances of real property, as well as most other interests in real property, must be recorded to be enforceable. All owners or parties interested in real estate need to record, or file, all documents affecting their interests in the real estate to give public notice to the world of those interests. This public notice is called constructive notice or legal notice. Physically taking possession of the property is actual notice. Necessity for recording. Through the process of recording, documents that affect property ownership are readily available as matters of public record. Therefore, a person can inspect the documents that affect a property before making a decision about purchasing it. A potential purchaser can verify that the seller can probably convey good title to the property as well as what liens and encumbrances affect the title. Example: a purchaser offering cash for a property might want to be sure, before the settlement takes place, that the seller has paid in full all of the debts outstanding against the property. By inspecting the recorded documents, the purchaser could determine what debts encumber the property. To serve as public notice, all instruments in writing affecting any estate, right, title, or interest in land must be recorded with the county recorder or, in North Carolina, the register of deeds in the county where the land is located. Lien satisfactions, such as a mortgage payoff, should also be recorded to clear the encumbrance from the title. Everyone interested in the title to a parcel of property can, with a thorough title search of recorded interests, therefore, receive notice of the various interests of all other parties. Because North Carolina is a pure race state, recording gives legal priority to those interests that are recorded first. North Carolina Connor Act. The Connor Act is a state law that provides that many types of real estate documents are not valid as to third parties unless they are recorded. The documents covered include deeds, mortgages, installment land contracts, assignments, options, leases of more than 3 years, easements, and restrictive covenants. Contracts to convey real estate as well as memoranda of contract are also covered by this statute. Under the Connor Act, if a purchaser fails to record a deed but a subsequent purchaser does, the subsequent purchaser's title takes precedence over the first purchaser's title. This kind of recording statute is called a pure race statute. Whoever records first prevails, even if that purchaser had personal knowledge of a previous interest that was unrecorded. Example: suppose Zackerman sells her property to Sands. Sands fails to record his deed. 2 weeks later, Zackerman sells the same property to Hansen. Hansen suspects that Zackerman no longer owns the property but accepts the deed and quickly records it. Because Hansen recorded his deed, he now has marketable title to the property, and Sands is out of luck. Sands' recourse may be to sue Zackerman, but Sands is not the owner of the property. Torrens System of Land Registration. The Torrens title system is a legal registration system used to verify ownership and encumbrances similar to the registration of ship titles. Registration in the Torrens system provides evidence of title without the need for an additional search of the public records. The registering government basically guarantees that the named person is the owner of the registered title. Under the Torrens system, an owner of real property submits a written application to register a title. The application is submitted to the court clerk of the county in which the real estate is located. If the applicant proves ownership, the court enters an order to register the real estate. The registrar of titles is directed to issue a certificate of title. The original Torrens certificate of title in the registrar's office reveals the owner of the land and all mortgages, judgments, and similar liens. It does not, however, reveal federal or state taxes and some other items. The Torrens title system of registration relies on the physical title document itself. A person acquires title only when it is registered. The Torrens system is governed by Chapter 43 of the North Carolina General Statutes, and is rarely used in North Carolina, as noted in the 2011 to 2012 edition of the North Carolina Real Estate Manual. Every owner of land registered under the Torrens system holds the land free from any and all adverse claims, rights, or encumbrances not noted in the certificate of title. In addition, no title to nor right or interest in Torrens registered land contrary to the rights of the registered owner can be acquired by prescription or adverse possession. Learning objective. Calculate excise tax due when property is transferred. North Carolina excise tax. All sellers of real property in North Carolina must pay an excise tax that is based on the sales price of the property. The statute states there is levied an excise tax on each deed, instrument, or writing by which any interest in real property is conveyed to another person. Prior to year 2000, actual revenue stamps were affixed to each deed as proof that this excise tax had been paid. Now, because the registrar of deeds must mark the document to show the tax amount paid prior to recording the document, the term revenue stamps has been discontinued. The amount of the tax is $1 for every $500 of consideration or fraction thereof, and always is expressed as a whole dollar amount. The type of financing used, if any, has no effect on the calculation of excise tax. The statute establishing the payment of excise tax exempts certain types of conveyances, such as transfer by a government entity, transfer by will or intestate succession because of death, transfer by deed of gift when no consideration is paid, transfer by merger or consolidation, transfer by lease for a term of years, and transfer by instruments securing a debt, such as a mortgage or deed of trust. A number of North Carolina counties have additional taxes on real estate sales, often referred to as deed transfer taxes. Calculate North Carolina excise tax. To calculate the amount of the excise tax, if the sales price is not an even $500 amount, round the sales price up to the nearest $500, divide by 500, and multiply by $1. For example, suppose the purchase price is $89,250. Round up the price to $89,500 and divide by 500, which equals $179. Multiply 179 by $1, and you have determined that the seller will need to pay $179 in excise tax. As another example, suppose the purchase price is $94,750. Round up the price to $95,000 and divide by 500, which equals $190. Multiply 190 by $1. The seller will need to pay $190 in excise tax. Key point review. Title is ownership or the right to ownership of land and evidence of that ownership. Voluntary alienation is the voluntary transfer of title to real estate by gift or sale, using some form of deed. Grantor must be of legal age and legally competent to execute a deed. A deed executed by a minor is voidable. Mental impairment at time of signing deed makes the deed voidable. If the grantor has been declared incompetent by a judge, the deed is void. All names the grantor has used should be provided. Grantee must be identifiable with sufficient certainty. Consideration of some form must be stated. Essential elements of a valid deed include the following. Granting clause must be used. Legal description of the property conveyed is essential. Exceptions or reservations of any relevance must be included. Signature of the grantor. Delivery of the deed and acceptance by the grantee are necessary. Non-essential elements of a deed include the following. Does not need to be dated. Does not need to show exact amount of consideration. Does not need to be acknowledged. Does not have to be recorded, but highly recommended. Does not have to be sealed. Types of deeds include the following. General warranty deed provides the greatest protection to the grantee, and includes covenant of cession warrants the grantor has the right to convey title. Covenant against encumbrances warrants the property is free from liens or encumbrances, unless expressly stated. Covenant of quiet enjoyment makes the grantor liable for damages if the grantee's title is found to be inferior. Covenant of further assurance, the grantor's promise to obtain any other document necessary to convey good title, and covenant of warranty forever, the grantor's promise to compensate the grantee if title fails at any future time. Special warranty deed includes the warranties that the grantor received title, and that the property was not encumbered during the time the grantor held title, except as otherwise noted. Bargain and sale deed implies that the grantor holds title and possession of the property, and there are no express warranties against encumbrances. Quitclaim deed provides the least protection of any deed, carries no covenants or warranties, and conveys only whatever interest the grantor may have when the deed is delivered. Excise tax is required to be affixed to deeds and conveyances before being recorded at the tax rate of $1 per $500 of value in North Carolina. Involuntary alienation of title to property is usually by operation of law. Escheat is property taken by state when deceased has no heirs. Eminent domain is property taken by public or government agency. Foreclosure is property taken by creditor for non-payment of debt secured by real property. Adverse possession is property seizure occurring when someone who is not the lawful owner takes possession of property for the length of time specified by state law, and usually in a way that is open, continuous, exclusive, adverse, and notorious. Transfer of title by will occurs when the deceased dies testate. Wills take effect only after death and can be changed by codicil, or revoked while the testator is still alive. Devise is a gift of real property by will to the devicee. Bequest is a gift of personal property to a beneficiary. Legacy is a gift of money. To pass title to property on death, the will must be filed with the court and probated. Wills cannot supersede state laws protecting inheritance rights or survivorship clause in the titles. Transfer of title under North Carolina Intestate Succession Act occurs when a person dies intestate. Probate proceedings must have an administrator appointed, and laws of the state where the real property is located govern property distribution. Chain of title is a record of property ownership, but it does not include liens and other encumbrances. A gap in the chain or other dispute of ownership creates a cloud on the title. A cloud on title is resolved by action to quiet title. An abstract of title, prepared by an abstractor or an attorney, is a summary report of what the title search reveals. It includes all recorded liens and encumbrances and lists records searched but does not indicate forgeries, and interests that are unrecorded or could be discovered by property inspection. A marketable title is one that must not have serious defects, nor rely on doubtful questions of law or fact to prove its validity, not expose the purchaser to litigation or threaten quiet enjoyment of property, and convince a reasonably well-informed and prudent purchaser that the property could be sold or mortgaged at a later time. Proof of ownership may be established by certificate of title, but it will not reveal unrecorded liens or rights of parties in possession. Unrecorded documents that may affect title, such as a tax lien, may not be recorded immediately, yet are still given priority by law, and require a search of tax records and other sources. To serve as constructive notice, and with priority over subsequent documents, a written document is needed that affects an estate, right, title, or interest in land, must be drafted and executed, is written according to state law, and is recorded in the public records that are maintained by the designated official, such as the recorder of deeds, county clerk, or city clerk, and held in the county in which the property is located. Public records are typically searched by closing attorneys and title companies that provide title insurance to prospective purchasers based on the findings of the title search. Constructive notice of a document is assumed when due diligence would reveal its existence. Actual notice means that an individual has direct knowledge of documents in the public records and facts revealed by an inspection of the property. North Carolina Marketable Title Act requires chain of title to be traced back only 30 years in most cases. Title insurance, issued as an owner's policy, or mortgagee's policy under which the insured is protected from losses arising from defects in title, insures against hidden defects and identifies exclusions that include readily apparent title defects, zoning, and others. The Connor Act requires recordation of most real estate-related documents to be enforceable against third parties. Excise tax is required to be affixed to deeds and conveyances before being recorded at the tax rate of $1 per $500 of value in North Carolina.